oil company from out of state, Sandridge, filed a request, appeared before the planning and zoning staff with a permit to drill a well in the west of Rio Rancho Estates. Under the current zoning ordinance, which is still in effect, and this is the one we're thinking about amending, that request was handled as a special use. A special use essentially means that it is not something that's dealt with anywhere else in the ordinance, and what oil and gas is specifically dealt with in a list of special uses that's contained within the ordinance. A special use means that at a minimum there will be 2 hearings, one before the Planning and Zoning Commission, this group, which then makes a recommendation to the Board of County Commissioners, which is the only organization that has power to grant a special use. It also means that each special use is considered as a standalone single item. It sets no precedence for anywhere else, and unless there's specific language in the ordinance regarding conditions that are to be met in order to obtain a special use, there are no specific conditions in the ordinance. Instead, the staff collects information about the special use that they then present to the Planning and Zoning Commission, and the Planning and Zoning Commission reviews that information in light of the broad standards that are set in the Planning and Zoning Ordinance, specifically health and safety concerns. The Planning and Zoning Commission then makes a decision. That decision can be appealed to the Board of County Commissioners. If there is no appeal, then the recommendation goes to the Board of County Commissioners that hold another hearing, or at least one hearing, and they make the final decision regarding the special use. So just as an illustration, when Sandridge filed their application, they filed maps, they filed a copy of the permits that had been issued by the Oil and Gas Division, or Conservation Division. They filed some material about what they proposed to do, and they were requesting an exploratory well, and that was the permit that they had from the Oil and Gas Conservation Division. We held a call for a public hearing. The attendance was so large that we moved from this room down to the hall on the first floor and set up folding chairs there. There were probably 200 people, I would guess, that were there. We heard testimony from representatives of the Oil and Gas Division. We heard we heard from the staff of the Planning and Zoning Commission, and then we opened up for public comment, and probably, I would guess, 50 people testified at that hearing. Based on the issues that had been identified by the staff and some of the comments that were particularly relevant to the issue of whether Sandridge should drill an exploratory well, and also some comments about Sandridge itself, which at that time was widely reported to be on the verge of bankruptcy. We prepared a list of 12 questions that we wanted Sandridge to ask, some of them very specific, some of them general, but many of them arising from comments that were made during the public comment part of the hearing. There was then a second hearing in this room at which the representative from Sandridge was asked to respond to each one of those 12 questions. And the representative responded, I believe, to 3 or 4, but then said that she was unable to respond to the rest of the questions. At that point, we then called for a vote of the Planning and Zoning Commission. The Planning and Zoning Commission turned down their request for a special use based on the fact that they were unable to answer the questions that they had been given. We expected that they would appeal that decision, our decision, or our recommendation to the Board of County Commissioners. Instead, they withdrew their application, and that was the end of it. The reason I mention this is because in the first meeting that we had a more in-depth briefing on special uses, because one option that's available is for us to recommend to the Board of County Commissioners, which is ultimately, well, which is the only body that has powers to make amendments to the zoning ordinance. We could make a recommendation to do nothing, that is to keep oil and gas as a special use. The advantage of that would be that then every single application for oil and gas development on private land in Sandoval County, that's the yellow and red that's shown on that map. The blue is all areas that are outside of our jurisdiction. The county has, it's largely federal and state, well, it is all federal, state, or tribal land, okay? So the blue, anything that we do here has no application in the blue part of that map of the county. So you can see that we're talking about a minority of the total land mass of Sandoval County where any oil and gas ordinance or any amendments will apply. If you look at the, well, okay. So anytime that anybody applies and comes to the county with a permit issued by the Oil and Gas Conservation Division and says, we want, here's the piece of land that we want to put our drilling rig on and we want to put our production facility on, we would consider that, if it's a special use, as a one-time item, and we would look in depth at just the circumstances around that particular request for that particular piece of land. Okay. Now, what's different in the ordinances, the amendments that are before us tonight, is we set a number of standards, and within those standards, precedents will be set. If we interpret the amendments to the ordinance in one way, we are setting a pattern which we will then have to stick to every time another request is made for land use for oil exploration or for oil production or gas production. And so the difference from our perspective, that is, as the writers of or reviewers of an ordinance that will ultimately go to the Board of County Commissioners, is we and the Board of County Commissioners have to think, well, so the language in the current ordinance can be traced back to the 80s. So basically we are working with about a close to 40-year-old document. Okay? And much of the language, particularly for the Algodones area and then in the 90s for the whole county, has remained unchanged for at least 25 years, and it's almost 40 years. So that puts us in a position of thinking ahead. What's going to happen with oil and gas in this county, in the yellow and red areas, in the next 40 years, and how do we write standards that will be good for potentially all of those 40 years. Now, obviously, you can come back and amend the ordinance whenever it's necessary, but once an application is filed, you cannot then say, oh my gosh, we forgot something in our ordinance before we act on this application that's already been filed, let's amend the ordinance. You can't do that. You have the ordinance that's in place on the day and time that the person files the application, that's the ordinance that's going to apply. And so if we find ourselves in a situation where some kind of new sort of drilling or whatever is forecast and it's not in the ordinance as written, we cannot then develop new standards for that. We have to go with the standards that are in the ordinance. On the other hand, if it's a special use where there are no standards in the ordinance, we can examine that particular application, that particular proposal, on that particular piece of land, and ask the questions that are related specifically to what's before us in that proposal. And that's why we said one of the things that we need to carefully consider is the difference between considering oil and gas development as a special use, which gives us great flexibility and establishes no precedence versus amending the current ordinance where we have to set standards and where then we have to live with whatever standards we've set, even if we later discover that it's not, that those standards don't fit very well with an application that's before us. So we're going to take comments in the public comment period. So I believe Makita's going to give us a briefing on, no, okay.
No, sir, if I may, Heather is going to, from the attorney's office, is going to give us a briefing on legal aspects of preemption, what preemption means. And then also, I've asked her to talk about evidence to be considered in zoning cases, because that's important. Even though we're just doing legislation right now, you should understand that a lot of things that are being said are not what would be considered expert testimony. And it's important to understand how that figures into decisions that you make when you're doing zoning cases. And then Makita will go over the preemptions with you and try and get through all of those as much as possible.
Okay. So I just need to make one very personal privilege. I'm going to have to leave at about 6:45 because I'm playing in an orchestra that has a concert on Friday night, and we rehearse for 4 nights and play a concert, and so missing a rehearsal is a very big deal, and I can't do it. If the music were easier, I'd skip it, but can't do it. Okay, so Heather, welcome.
So first, let me talk about the cases that I found regarding the evidence in a zoning case.
Probably need to speak, just pull it a little closer.
The first one is Dick versus City of Portales, and the other one is City of Santa Fe versus Woodward. They both involved liquor licenses. So in Dick versus City of Portales, somebody was asking to have a liquor license transferred to their restaurant. The city council had
Speak into the mic.
The city council had a hearing, and at the hearing, a minister got, and there was at the city council meeting, there was a public hearing regarding this liquor license, and there was testimony for the restaurant from the city itself talking about traffic control and how this wouldn't affect traffic, and in fact actually denying the liquor license would cause the restaurant to be open longer, so that would actually impact traffic. But then on the other side, there were some people that testified about studies that had been done that when there's liquor license in an area, DUIs go up, and that this causes traffic issues. And there was a study presented from Pennsylvania, but there was nothing, but the court made it clear that the study, there was nothing backing up the study, that the person that introduced it just said there's a study that DUIs go up, but nothing, and that one beer can cause impaired driving. But there was nothing saying that this study was accurate or what the basis for the study was. And so there again, the court said there was nothing linking this particular case to the harms that people were testifying about. There was nothing specific about it. That if there had been something about where this restaurant was going to be that was different than where the other restaurants were, they said if there had been testimony about that, then yes, that would have been specific. But because there was nothing specific to that restaurant and the testimony was irrelevant. And so those are the types of evidence, and these were both zoning cases of people. The ordinances were already there, and they were just trying to get the zoning, through the zoning. Preemption, which is the other topic, there's 2 preemptions. First, on the federal level, the Supremacy Clause in the U.S. Constitution says that the U.S. Constitution and that the laws of the federal government are supreme. So state laws and local laws have to be careful and not conflict with federal laws, otherwise the federal laws trump. The other type of preemption is within states. The states give the counties their powers. And that's done, and so the state, when the state grants powers to the county, they can also essentially say, we're reserving certain powers for ourselves. And and with regard specifically to oil and gas, when they passed the ordinance in Mora County, that was actually one of the reasons that the federal court struck down that ordinance, was because they said it conflicted with the state laws.
Okay, say that again, please, louder into the mic, that last sentence.
Mr. Chairman, please, can we allow the speakers to speak without interruption from the
I
public?
couldn't hear.
I'll repeat that.
I'm just
Part of the reasoning for striking down the Moore ordinance was because the federal judge said that it conflicted with laws in New Mexico. That the state does have laws in New Mexico regarding oil and gas. They haven't completely taken over the field, but they are in the field, and so the counties have to be careful in how they pass ordinances so that they are not, so that they don't conflict with the state ordinance. They were very clear in that case that that there are certain things that counties are able to regulate, such as noise control, traffic control, things like that, that are left to the counties. But that the counties do have to be careful because of the preemption. And there is the main case there's two cases that set out state preemption, which is San Pedro Mining Corporation versus Board of County Commissioners. And it says that a local governmental body's ability to regulate in an area may be preempted either expressly by a language of a statute or impliedly due to a conflict between the local body's ordinances and the contents, purposes, or pervasive scheme. So if a local ordinance conflicts with any state statute, the state statute is seen to be preempting that local ordinance. The other case regarding that is Board of Commissioners of Rio Arriba County versus Gratian. And it says that when the local ordinance merely complements and is not antagonistic with the statute, the ordinance will stand. But an ordinance conflicts with state law when state law specifically allows certain activities or is of such a character that local prohibitions on those activities would be inconsistent with or antagonistic of the state law or policy.
Okay. Questions for Heather?
Heather,
Yeah. We have a period of public comment and make public comment. Okay, we tried getting questions after each testimony in the last meeting and it did not work, so we're not doing it. So go ahead, I'm sorry.
just for my clarification, that OCD falls under the state, so that's right under state law.
That is correct.
Okay.
I have one question. It doesn't really apply to exactly what you're saying, but it still applies to what we're trying to get to. Does special use create case law?
It could. If somebody could appeal a permit denial up to the courts, and it could create case law. The cases that I've seen are not special use. They were when there was already an ordinance and a procedure for getting a permit for something versus the special use. But it could create case law.
Strictly at the planning and zoning level, does it create case law? Could one decision affect another decision if a special use permit was requested further down the line?
Not directly, no. I could think of maybe an instance where if they were inconsistent.
So I think, Mr. Chair,
Right.
I
Make
think
sure your
it
mic's
was,
on.
I think it was stated that
I don't think.
earlier, depending on the wording, that could affect
Correct.
and create.
Correct. Yeah. And the way that from a planning and zoning that it would create case law is when the planning and zoning makes a decision and it goes up to county commission and then somebody appeals it up to the courts and it goes all the way up. That's those two liquor license cases, that's how they ended up with the Court of Appeals.
Thank you.
Thank you.